Hello, all of you. It's a great honor to be here, and I just wish to congratulate you on this largest child rights conference that I think has been held ever in the whole of Europe and probably the whole world. Now, when I was approached by Cecilia Sjölander, who invited me here to speak at this event on the concluding observations, or the COPs as we call them, following Sweden's review on the implementation of the convention, I did not think twice. Knowing the remarkable history of allmänna barnhuset and the wonderful work that this foundation has accomplished, I felt, of course, honored to accept such an invitation. And I also felt obliged and privileged to do so should I be able to contribute to the current dialogue on children's rights in Sweden. The huge legacy of Swedish welfare model, including the historical role Sweden has played internationally in furthering children's rights, is unique. The Committee on the Rights of the Child is abundantly aware of this fact, not the least Sweden's pioneering legislation from 1979 prohibiting corporal punishment of children, as well as of the diverse follow-up measures taken since with aim to realize these legal reforms. In its monitoring activities, the committee is still engaging in discussions with 2/3 of the world's nations that still have not banned corporal punishment. During these communications, the committee frequently cites Sweden's accomplishment and the value we believe your experience has had for promoting and practicing non-violent upbringing of children in all regions of the world. The standards that Sweden has set are high. Thus, the committee must set even higher standards if progress is to be made in the journey to realize the overarching and cross-cutting rights of the child embodied in the Convention. This has been a challenge for the committee, and it's your privilege to determine to what extent, if any at all, this task has been accomplished. Before I highlight some of the issues raised in the COPs for Sweden, I wish to express appreciation for the valuable supplementary reports submitted, as well as the broad-based consultations and constructive engagement that the committee has had with civil society organizations such as Allmänna barnhuset, human rights institutions such as the Barnombud, and of course the children themselves. I know that many of you were part of this process, and I want you to know that the committee is well aware of how much we have benefited from your work, without which effective monitoring process would not be possible. The outcome of the monitoring process is, as you know, documented in the COPs. The COPs are typically a very detailed and comprehensive reports, approximately 7,000 words of length and 15 pages, and contain numerous recommendations to the state party. If I'm not mistaken, the COPs for Sweden from January this year contain about 125 recommendations to the Swedish government, besides a number of other comments such as welcoming remarks, notes and concerns. Now, very importantly, the committee always highlights up to 6 priority recommendations that, in respect of which urgent measures must be taken, as the literal wording of the COPs is formulated. Now, in my speech today, I will highlight these 6 priority areas, in particular the recommendations on violence, which is, of course, one of these priorities. However, I just first want to mention the positive development that the committee identifies with regard to the implementation here in Sweden. And not surprisingly, the committee identifies the integration of the Convention on the Rights of the Child into the national legislation by the act that came into force in 2020 as the most significant step in consolidating the rights of the child in Sweden. And I know the committee is extremely interested in learning about the assessment of the impact of this development in due time. But there are further positive remarks. It's like the committee welcomes the establishment of the Institute for Human Rights last year, as well as legislative reforms, such as the amendment to the Criminal Code in 2022 with the aim of strengthening protection for children against sexual exploitation. Now, the 6 priorities that Sweden urgently needs to address are independent monitoring, non-discrimination, violence, including sexual exploitation and abuse, education, asylum-seeking refugee and migrant children, and administration of child justice, or juvenile justice, as we used to call it. Now, with regard to independent monitoring of the Convention, the committee remains deeply concerned that the Ombudsman for Children, despite previous recommendations from the committee, has not had the mandate to receive complaints from children. Moreover, the committee is concerned that the independence of the role of the Ombudsman could be brought into question owing to its reliance on funding linked to this specific government assignment. Now, it's my understanding that up to a third of the budget of the Ombudsman is not under the effective control of the Barn Ombudsman. Now, the committee makes 4 recommendations in this context, including one on measures to ensure adequate funding for the monitoring of the integration of the Convention into the national legislation, which is extremely important, as well as measures to ensure that the Ombudsman can operate in accordance with the Paris principle of human rights, in which independence is one of the 3 key pillars. Now, with regard to non-discrimination, which is the second category of rights, the committee suggests urgent measures to be taken. Now, while the committee welcomes the strategy and the adoption of the action plan for equal rights and opportunities for LGBTIQ people, and the inquiry on the Discrimination Act, it is from 2008, it's deeply concerned about a number of things. The absence of data on discrimination against children, the persistent discrimination through the expressions of racism, racist attacks and bullying against children in disadvantaged situation, and third and finally, regional inequality. The committee makes 5 recommendations on discrimination, including the disparities between municipalities in terms of access to services, as well as the need to strengthen the legal framework on discrimination. Now, the third priority is on education. Now, again, while the committee notes the principle of inclusive education, it remains concerned about disparities in access to quality education, and secondly, as well as harassment and bullying in schools. The committee makes 8 specific recommendations with regard to elementary and secondary education, and these include access to quality education, particularly for children with disabilities, minority groups, asylum seekers and migrant children, and children in care. The other recommendations are strengthening measures to combat violence in schools, including sexual harassment, bullying, cyberbullying, and online violence. Moreover, to ensure that measures that encompass prevention, early detection mechanism, intervention protocols, as well as empowerment of children, and awareness raising on the harmful effects on violence. An emphasis is also placed on developing guidance and mandatory training for teachers in addressing violence in schools, as provided for under the Education Act, with a view of preventing the abuse or misuse of the provisions allowing for physical interventions by teachers to tackle violence and ensure that such measures take a child-sensitive approach. Now, the 4 sets of priorities that the committee urges the Swedish government to address are on asylum seeking, refugee and migrant children, including unaccompanied children, Now, the committee notes with appreciation, again, the work of the Swedish Migration Agency in assessing the best interests of the child, including the child-specific grounds for asylum. However, the committee is deeply concerned about the impact of the amendments of the 2021 Aliens Act, restricting, among other things, family reunification. And in particularly, we are concerned about the 33 reforms envisaged in the T2 agreement for further restrict the rights of asylum-seeking refugee and migrant children. The committee introduces 8 specific recommendations pertaining to measures to strengthen the rights of these vulnerable groups of children, including on psychosocial support and the protection from sexual exploitation and sexual abuse. The 5th priority concerns the administration of child justice or juvenile justice. And here the committee is deeply concerned about the current moves to lower the age of criminal responsibility, the increasing involvement of children in organized crime, solitary confinement of children, and recent legislative amendments introducing more severe sentences and invasive measures by law enforcement authorities. In this context, the committee made eight recommendations. These include maintaining the current 15 years of age criminal responsibility, limiting the use of deprivation of liberty, abolish solitary confinement of children in conflict with the law, as well as various measures aimed at strengthening child-friendly justice. The 6th and the final priority, which is violence, which is indeed one of the 6 priority areas of the COPS. Violence is referred to in multiple contexts. However, the comprehensive recommendations of violence are to be found in the chapeau on violence in the COPS, and they are based on concerns that are as follows. First, the high level of violence against children, including sexual exploitation, gender-based violence, and online violence. Now, this has been further demonstrated to be an issue in the newest report by allra, barnahuset, våld mot barn, just recently published. Now, secondly, the low rates of reporting, prosecution, and convictions in cases of child sexual exploitation and abuse, and light penalties such as fine or short sentence prison sentences for perpetrators. The third is the particular vulnerability of girls, particularly with disabilities and children in alternative care, and children in socioeconomically disadvantaged situation. The 4th concern is that violence against children in institution, and particularly sexual abuse of children, and especially would like to mention girls in closed institution or compulsory care. We had information that are worrisome there. The lack of legislative framework for ensuring multi-sectoral coordination and quality standards for comprehensive support services for victims of violence, and the fact that not all children have access to specialized support. I will come back to this. The insufficient capacities of professionals working with and for children to recognize and respond to cases of violence against children, including deficient resources of local social services. Now, what are the recommendations of the committee in this context? First, the committee welcomes the new and comprehensive strategy for preventing and combating violence against children that was adopted by the government. In fact, the day after the review on the 18th of January, so we did not have the possibility to study it thoroughly. The committee recommends, though, that an integrated action plan for the strategy should be developed, which should include targeted measures for girls, children with disabilities, children in socioeconomically disadvantaged situations, migrant children and children belonging to minority groups, and that it is and that's the important one, adequately resourced and comprehensively addresses sexual exploitation and sexual abuse. To ensure that children have access to confidential and child-friendly complaint mechanism, including helplines. I could hear the last speaker was highlighting one of the issues we are dealing there, that children perhaps do not know the mechanisms that are available for reporting. Now, third, to ensure the effective investigation of and intervention in all cases of violence against children in and outside the home, and ensure that in cases of sexual exploitation and abuse, perpetrators are appropriately prosecuted and punished. And this is followed by two recommendations that really are specific to barnahuset. The first one, to adopt legislation aimed at ensuring multi-sectoral coordination in investigation and comprehensive quality standards of support services of barnahuset, including for forensic interviews, medical evaluation, and therapeutic support. And the other one, to strengthen measures for ensuring that all children who are victims and witnesses of violence have prompt access to information about remedies to ensure their recovery and reintegration, and to child-friendly and multi-sectoral remedies and comprehensive support, including in a barnahuset, with the aim of preventing the secondary victimization of those children. To further strengthen awareness and education programs, including campaign with the involvement of children to enhance awareness of gender-based violence and sexual exploitation among the public and professional, and to identify and adequately respond to all cases of violence against children, to incorporate training on violence against children in relevant higher education and training programs, including in applying the guidance developed by the National Board of Health and Welfare, Socialstyrelsen, on supporting children at risk. And finally, to ensure the systematic collection and analysis of data on gender-based violence and sexual abuse and exploitation, including on cases that have been reported to the authorities, investigated and prosecuted, and on sanctions that have been imposed on perpetrators, as well as data collection to support or inform the implementation of the national strategy to prevent and combat violence. Now, dear all, in the concluding part of my speech, I would like to emphasize the committee's urgent recommendation that Sweden take legislative measures to ensure the access of all children who are victims and witnesses of crime to barnahuset, and to consolidate the quality of services provided in barnahuset, which is unfortunately lacking in the government strategy. Now, some of you may know that my main professional mission in life has been for almost a quarter of a century to promote the barnahuset model in my capacity as the Director General of the government's Agency for Child Protection in Iceland. I pioneered the first barnahuset in 1998, inspired by the US Children's Advocacy Center model on the one hand and the Nordic welfare model on the other. Thus, barnahuset became different from children advocacy centers in two basic ways. One, on the one hand, by integrating the judicial component by eliciting the child's testimony narrative under the conditions of the due process on the pre-trial states without delay, and allowing for the video recording of interviews as the main evidence in the court procedure. The aim was to preserve the child's narrative as evidence and to avoid re-traumatization of the child victim by long and distressing wait for trials, even for years, as well as the intimidating cross-examination in courthouses. The other difference was that the barnahuset became a public institution, and its function an integral part of the public social health and judicial services, instead of being privately funded agency like the CAC in USA are. Now, barnahus is now to be found in 20 European states, and there are several more in the pipelines. The proliferation of barnahus has been due to many factors. In the early stages, advocacy of civil society, like Save the Children or Allmänna barnhuset, and support by professional communities such as ISPCAN, had a great impact on this development. In 2015, a systemic effort to provide technical assistance to establish barnahus in Europe took off under the banner of the Promise Project, which is operated by the Council of the Baltic Sea States in Stockholm, as you may know, and supported by the European Union funding. This has speeded up the process, including by providing the most advanced quality standards for barnahus. Moreover, the advocacy activity of the Council of Europe for the past decade, as the current formulation reflects, towards barnahus in all European states, ensuring the rights of every child, and this has also motivated many governments in implementing barnahus. The strengthening of child rights in the evolution of European law has certainly facilitated the proliferation of barnahus. The Council of Europe instrument, Guidelines on Child-Friendly Justice from 2010, the Lanzarote Convention, a binding instrument ratified by all member states of the Council of Europe, has provided a firm legitimation which was strengthened even more by the EU directives on sexual abuse and sexual exploitation in 2011 and the rights of victims of crime in 2012. Now, these fundamental European laws have impacted the jurisprudence of the European Court of Human Rights. Recent judgments of the court are crucial in guiding states how to put in place mitigating measures to avoid the adverse impact of the judicial process on child victims and witnesses. In two landmarking judgments from 2021 and one from earlier this year, the court explicitly instructs states to apply the Lanzarote Convention as well as the soft law, the Guidelines on Child-Friendly Justice, together with the Convention on the Rights of the Child when fulfilling their obligation to protect children from sexual exploitation or sexual abuse. And in doing so, states should adopt less strict procedural rules. This is their wording, for children's testimony with the aim to ensure the child's rights to dignity and psychological integrity and to avoid further victimization. During the past 4 years, the Committee on the Rights of the Child has consistently recommended child-friendly and multi-agency response to child sexual abuse and exploitation. Furthermore, should barnahus be mentioned in the state reports or documents submitted by civil society organizations or human rights institutions, the committee has, as a rule, has explicitly recommended barnahus in the concluding observations. Now, this is truly a remarkable development, albeit not surprising, bearing in mind that the fundamental principles of the Convention on the Rights of the Child are so firmly embodied in barnahus. Why is it important to address barnahus in the COPs for Sweden and the significance of providing legal framework? Now, as said before, not all children have access to barnahus, nor is the equality of their services the same across the country. However, in my mind, there is more to this. Since 2005, from the opening of the first barnahus in Linköping, Sweden has been leading in the development of barnahus and a role model for professionals and child rights advocates all over Europe. The long-standing pioneering work of Sweden in child protection and welfare services for children and families has been an inspiration for other countries, including the ingenious and ambitious services of many of your barnahus. Delegations from all over Europe have visited barnahus in Sweden, in Linköping, in Stockholm, in Karlstad, and other locations to receive information, support, training on the diverse functions of Barnahus. Inadvertently or not, due to your generosity, Sweden has inspired hundreds of professionals and thus taken on a responsibility that you need to live up to. That's why nothing less than Barnahus as centers of excellence should be acceptable to Sweden. Thank you for listening.